In 1945, an international tribunal convened at Nuremberg to prosecute men who had broken no law of their nation. And to do it, they invoked a law older than any parliament, older than any church. A law, they said, was written into the nature of things itself. The defendants had followed orders. The orders had been legal. The regime that issued them had passed them through the proper instruments of German legislative authority. By every measure of legal positivism, the doctrine that law is whatever the state enacts, there was no crime, and yet men were convicted and executed. The tribunal needed a law above the law. They found one. It had been there for more than 2,000 years. That is the argument this video is going to trace. From its oldest documented witnesses, through the man who built it into the architecture of Western legal thought, through the specific moment when one man applied it in silence in a courtroom in 1535, and back to 1945, when a secular international court, not a church, not a synod, not a denomination, reached for the same structure and used it to convict the architects of the worst institutional atrocity of the modern era. What you're feeling right now when you watch an institution you gave decades to quietly redefine itself in ways that cannot be named out loud, when you know something is wrong but cannot say why in terms the room will accept, is not sentiment. It is not nostalgia. It is not tribal preference. It is the surface of something that goes very deep. The tradition has a name for it, and the name comes with an argument. There is a scene in Sophocles, 5th century before Christ, that Aristotle thought was worth quoting in a treatise on rhetoric, not because it was moving, because it was evidence. Antigone has been condemned for burying her brother in defiance of the king's explicit decree. Creon had issued the order. Creon had the authority to issue it. The law was clear, and Antigone stood before him and said, in effect, "There is a law that yours cannot reach." She named it. She said it was not written by any man. She said it did not begin yesterday or the day before. She said it lived, always. Aristotle was not a theologian. He was a philosopher of nature and politics, and he cited this passage in the Rhetoric as a documented example of what he called natural justice, a justice that exists prior to and independently of any convention, any statute, any decree. He distinguished it explicitly from legal justice, which is whatever a given community has established. Natural justice holds everywhere. Legal justice holds only where it has been enacted. That distinction is older than Christianity. It is older than Rome. It was already a settled philosophical category when Cicero built it into the foundations of Roman jurisprudence. Cicero's De Republica survives only in fragments. The passage that matters most was preserved by a later writer, not by the original manuscript. But it is preserved, and what it says is this: there is a true law, right reason in agreement with nature, universal in application, unchanging and everlasting. It summons to duty by its commands and averts from wrongdoing by its prohibitions. Its commands and prohibitions always influence good men, but are without effect upon the bad. To invalidate this law by human legislation is never morally right, nor is it permissible ever to restrict its operation, and to annul it wholly is impossible. Neither the Senate nor the people can absolve us from our obligation to obey this law. Neither the Senate nor the people. Cicero was not speaking about religion. He was not invoking divine authority in the sense of special revelation. He was making a claim about the structure of reality, that there is a law woven into the nature of things, that legislative authority cannot create it, cannot suspend it, and cannot dissolve it. This is the claim the state fears, not the claim that God exists, not the claim that the church should have authority over the state. This specific claim, that the authority of the legislature has a ceiling it did not build and cannot remove. Every absolute state in history has understood this with perfect clarity. The moment you accept that legislative authority has a ceiling above it, you have accepted a principle that places something beyond the reach of the state's most fundamental instrument. You have accepted that a law can be enacted through every proper procedure, signed by every proper authority, and still not be law in the only sense that matters. That is not a preference. It is a structural threat. By the 12th and 13th centuries, the tradition had accumulated enough material. Aristotle recovered through Arabic scholarship, Cicero built into Roman law that the church had inherited and developed, the Stoic tradition absorbed into Christian thought that it needed a synthesizer. It got one. Thomas Aquinas, writing in the Summa Theologiae in the 1360s, built the most precise version of the argument that had yet existed. He distinguished four kinds of law: eternal law, the rational order by which God governs creation; natural law, the participation of rational creatures in that eternal law. What human reason can apprehend about the moral order by examining the nature of things? Human law, the positive statutes enacted by legitimate authority for the ordering of civil life. And divine law, special revelation, scripture, and its authoritative interpretation. The crucial move is this. Human law, for Aquinas, derives its binding force from natural law. It is not self-authorizing. A statute is not law merely because a legitimate authority enacted it. It is law because it is a just determination of what natural law requires in particular circumstances. The authority to legislate is real and necessary, but it is not unlimited. Here is what Aquinas wrote in question 96, Article 4 of the Summa. He did not write the crystallized phrase that later thinkers would compress his argument into. What he wrote was this: an unjust law is not a law simply speaking, but rather a perversion of law. A perversion of law, not a bad law, not an unjust law that is nevertheless binding, a perversion of the category itself, something that wears the form of law without possessing its substance. He went further. He specified when disobedience is not only permitted but required. When human law contradicts the divine law or the natural law, it does not bind the conscience. It cannot. Because its authority was derived from a source it has now violated. The legislation that contradicts the law above it does not merely overstep, it collapses the very ground on which it stands. Aquinas was not a revolutionary. He was not licensing insurrection or the private invalidation of inconvenient statutes. He was making a precise philosophical claim about the architecture of authority, about where legislative power comes from, what it is for, and what happens when it turns against the source of its own legitimacy. The state has understood this precisely. It is why the concept of natural law has been the consistent target of every political philosophy that sought absolute legislative sovereignty. In the 19th century, legal positivism, the doctrine that law is simply whatever the state enacts, emerged as the dominant framework in European jurisprudence. It was not designed to accommodate Aquinas, it was designed to replace him. And for a while, it seemed to succeed. Then came 1933. Before we reach 1945, there is something worth pausing on. The kind of thing this video can only point toward, not give you fully. What made More's silence possible, what made it something other than stubbornness or performance, was not that he understood the argument. He understood it with the precision of a man who had spent his career in the law. But understanding an argument and being able to hold under the actual weight of a tower cell in a treason charge are not the same thing. More practiced something. He described it in his letters. He had spent years before any of this began, deliberately meditating on death, not as a morbid exercise, but as the only honest preparation for a moment when the question of what you actually believe would not be theoretical. The Memento Mori practice guide draws directly on More's documented practice, 30 days of structured reflection built from his prison writings, the specific questions he was working through in the tower, and the primary text excerpts that show how he actually used the tradition, not just how he understood it. If you want to build the interior that made the argument livable rather than merely logical, that's what the guide is for. The link is in the description. In 1534, Henry VIII's Parliament passed the Act of Supremacy and the Treason Act. The Act of Supremacy declared the king the supreme head of the Church of England. The Treason Act made it a capital offense to deny that supremacy in words. Note what it required: words. An explicit verbal denial. The statute was designed with a specific vulnerability in mind. It needed a statement it could prosecute. It could not prosecute silence. Silence was not denial. Silence was not affirmation. Silence was silence. Thomas More understood statutes. He had been Lord Chancellor of England. He had spent his career reading the law with the precision it demanded. And when the commissioners came to the tower to ask whether he accepted the king's supremacy, More said nothing about the supremacy. He said in the words Roper recorded, "I do none harm. I say none harm. I think none harm. And if this be not enough to keep a man alive, in good faith I long not to live." What the record implies, and this is inference, not documented statement, is that More was not hiding. He was refusing to give the state a weapon it had not yet manufactured. The law required a denial. He would not supply one. The law could not prosecute silence. He would give it nothing else. But there is something beneath the legal strategy that the legal strategy alone does not explain. More was not a man who lacked words. He had spent his life producing them in correspondence, in controversy, in counsel to the king, in the writings from the tower that continued until the final weeks. He was not silent because he had nothing to say. He was silent because the thing he would have said, that no parliament could make the king head of the church, that the act was a perversion of law in the precise sense Aquinas had described, could not be said within the categories the court was prepared to accept. He was not hiding his position. His position was transparent to everyone in the room. His judges knew it, his family knew it, the king knew it. The silence was not concealment. It was the refusal to collaborate in his own prosecution by translating a conviction into the statutory vocabulary the Treason Act required. When the silence broke, when Moore finally did speak after his conviction had been recorded, he named it. He said that the act was contrary to the laws of God and his holy church. He said that no temporal prince could presume by any law to take upon him the rights that belonged to the See of Rome. He said these things knowing they were the statement the court had needed and failed to manufacture. He said them because the trial was over and the only thing left was the record. He was not performing. He was making a statement about the architecture of authority. The same architecture Aquinas had described, the same architecture Cicero had named, the same architecture Antigone had appealed to in the 5th century before Christ. That the state had enacted the law he stood against did not make the law legitimate. That the king had signed it did not make it binding on a conscience that answered to a law the king did not write. He understood that this position would cost him everything the institution could take. He also understood, and this is where the interior preparation becomes visible, that there were things the institution could not reach. Now return to Nuremberg. In 1945, Robert Jackson, the chief American prosecutor and associate justice of the United States Supreme Court, rose to open the prosecution. He was not a theologian, he was not invoking the church, he was a secular legal authority representing a secular international tribunal. And he said this: "The wrongs which we seek to condemn and punish have been so calculated, so malignant and so devastating, that civilization cannot tolerate their being ignored, because it cannot survive their being repeated. That 4 great nations, flushed with victory and stung with injury, stay the hand of vengeance and voluntarily submit their captive enemies to the judgment of the law is one of the most significant tributes that power has ever paid to reason. The law. Not the German law, which had authorized what was being prosecuted. Not any national statute. The law, singular, as if it had an existence above and prior to the legislative instruments of any particular state. The Nuremberg Tribunal did not call it natural law in those words. But what it invoked was its structure. It prosecuted men for crimes against humanity, a category that did not exist in any positive statute when the acts were committed. It held that certain acts are criminal regardless of whether the state that ordered them had the legal authority to do so. It held that following legal orders was not an adequate defense, because some orders are, in a precise sense, not law. Aquinas in the 13th century. Jackson in 1945. The language is different. The structure is identical. The tradition did not need the church to vindicate it at its most consequential modern test. The enemies of the tradition, or at least the judges of the tradition's enemies, invoked it themselves. Pressed to the wall by the most catastrophic failure of legal positivism in human history, the international order reached for the only framework that could explain why what happened was not merely terrible, but wrong in a way that transcended the authority of any legislative body. What is worth attending to is not that the tribunal arrived at the right verdict. It is that to arrive at any verdict at all, it needed a law above the law, a law it did not write, a law no parliament had enacted, a law that had been there in the record for more than 2 millennia, in Aristotle's citation of Antigone, in Cicero's fragment, in Aquinas' Summa, in the silence of a man in the Tower of London who understood 4 centuries before Nuremberg exactly what was at stake when the state claims authority it does not possess. The bishops who signed the oath of supremacy are worth a moment. Most of them did. Most of the English episcopate, when pressed, found a way to accept the king's supremacy, found the language that was defensible in isolation, found the argument that this was a matter of governance rather than doctrine, found the framing that allowed the institution to survive with its form intact. The institution survived. What it became is a different question. The Church of England is a real church, with real people and real faith. And nothing in this channel's voice has contempt for it. But what Moore saw, what his silence was a testimony to, is that an institution that accepts a perversion of law as law in order to preserve its institutional form does not preserve itself. It replaces itself with something that wears the form. The bishops who signed have descendants. They lead institutions. Those institutions have, in many cases, spent 5 centuries making the same kind of accommodations. Each one defensible in isolation, each one a small adjustment. The cumulative effect visible only to someone who can remember what the thing was for. This is not an argument about which institution to attend. It is an observation from the record about what happens to institutions that accept the state's framing of what law is, that accept, in practice, the positivist claim that the legislature's authority is the ceiling rather than the floor. More did not survive. The institutions that accommodated did. Whether they survived as themselves is the question the record leaves open. What you have, if you have followed the record this far, is not a religious argument. It is a philosophical argument that predates Christianity, that Christianity received and developed with extraordinary precision, and that the 20th century's most consequential international tribunal invoked without attribution, without acknowledgement, but without alternative, at the moment when legal positivism's catastrophic failure could no longer be talked around. The argument is this: there is a law that human legislative authority did not write and cannot revoke. The authority to legislate is real and necessary. It is not unlimited. A statute that violates the law above it does not merely overstep. It loses, in a precise technical sense, its claim to be law at all. That is not a sentiment. It is not nostalgia. It is not the preference of a tribe. It is the argument Antigone made. It is the argument Cicero made. It is the argument Aquinas built into the architecture of Western legal thought with more precision than any thinker before or since. It is the argument more applied in silence in a courtroom in 1535. It is the argument the Nuremberg tribunal needed and used in 1945. And it is the argument you have been reaching for every time you have tried to say that something is wrong in a way that is not merely your opinion, and found that the public square had no category for what you were trying to say. The tradition built the category. The tradition has been building it for 2,500 years. The question the record cannot answer for you is what you do with it now, not what you feel about it, what you do. The tradition has always distinguished between understanding a law and living under it, between knowing the argument and building the interior that makes the argument more than theoretical when the pressure is actual and the cost is real. More knew the argument for decades before the Tower. What the Tower required was something the argument alone could not provide. If there is a name you'd be willing to say out loud, an institution you've watched quietly cross a line it wants to find itself against, a conviction you've stopped voicing because the room no longer has a category for it, the comment section is here for that, not for grievance. For the record, the question of whether the tradition is right is not a matter of which institutions have survived. It is a matter of the full account.